gave me one thing. Ms. Giorgio?
Good morning, Your Honors. Mary Giorgio for the Town of Harwich Conservation Commission, and with me is Attorney Jeffrey Blake. I guess we could say that we're going from barns to barnacles. I don't know if the court would like a recitation of the facts, or should...
You may use your time any way you please, but you can assume that the justices have read the briefs.
I think then I will go right to the substance issues. There were three claims made by the Oyster Creek boat owners when they petitioned to the Conservation Commission and were denied a permit. And when they made their certiorari case, they claimed first that there was a constructive grant of their permit because the Conservation Commission did not issue their decision on time, and they also claimed that the court should annul the decision, denial decision, because the Conservation Commission violated the open meeting law. And then lastly, they claimed that what happened is that the appeal to the DEP eventually resulted in a superseding order of conditions permitting the project, and that superseding order of conditions preempted the local bylaws denial, if indeed the local bylaws denial was based on the same level of stringency of regulation as the state act. Now, with respect to the constructive grant argument, there's no doubt that the local bylaw, and we are going to be talking about the local bylaw here and what the requirements are under the local bylaw. The local bylaw does require that a decision shall issue, and that's the operative term, within 21 days. A written decision shall issue within 21 days of the close of the last public hearing on the project. And just assuming that the last public hearing was September 16th in 2003, the deadline for the issuance of the decision would be October 7th, 2003. And the record demonstrates that there's no dispute that on October 7th, the Commission did issue a written decision and signed it with the majority of its members. It also demonstrates the record that the decision was mailed out 2 days later on October 9th. In our brief, we argued that the shall issue means, that part of the bylaw means the essence of the thing. And the essence of the thing is the decision itself, including the setting of the decision down in writing, and not the notification, the mailing out. And we cite several cases to that effect. But even if the court would agree with the Superior Court, and evidently the Superior Court's finding is that the issuance date was the mailing date, not the date that the decision was actually made and written down. And that mailing date was October 9th.
So the decision is dated October 7th?
It's dated October 7th. It was mailed out on October 9th.
Okay. And filed in the City Hall or wherever it's filed on October 7th?
I believe so, Your Honor, yes.
Believe?
I don't know for sure. It's not a requirement under the bylaw to file it with the town clerk, as it is in the case of the Zoning Act.
So where do these decisions, when they're made, go for if somebody wants to look at them? In the office of the Conservation Commission?
They're in the office of the Conservation Commission, and the decisions have to be filed by the applicant when they're received with the registry. Even if this court would agree with the Superior Court that the date of issuance has to be the date of mailing, the bylaw is silent as to any remedy for an untimely decision. And we would submit that a constructive grant is a particularly draconian remedy, should not be granted by this court.
Is there any cases in any analogous area interpreting the word issue?
Well, there are some cases in the ones that they're in our brief where the issuance is, and as I mentioned before, goes to the essence of the thing, the actual decision, the writing down of the decision, and so on, and not the notification. And those cases are cited in our brief.
Okay.
Well, if the 21 days didn't have any real significance, they wouldn't have used the word shall, right?
That's right, but again, shall is defined in several of the cases that we cited as a directory rather than a mandatory action when there is no remedy provided in the bylaw and where the essence of the thing is the actual action that has to be accomplished by, in this case, the Conservation Commission. And as I say, there are several cases in our brief that discuss this. But what I would say is that even if it was mandatory and the Conservation Commission did violate its own bylaw by issuing on the 2 days late, that this court should not import the draconian measure of a constructive grant into the bylaw. And I would refer you to your own Clean Harbors case, where it's not a constructive grant case, but Clean Harbors argued that a grandfathered clause should be imported into a statute because Clean Harbor argued that the legislature inadvertently admitted such a clause and that omission interferes with the purposes of the statute as it was enacted. This court refused to import such a clause to that legislation. So too here, the boat owners contend that because the local bylaw is silent as to the remedy for an untimely decision, this court should import a constructive approval remedy into it. But as in the Clean Harbors case, this court should reject such legislation by judicial fiat.
Well, what if it was 6 months late or 9 months late? What do you do then?
Well, the applicant certainly has a mandamus action available to it. And as a matter of fact, as a practical matter, Your Honor, as you know, these conservation commissions are two-level decisions. They make a decision under the State Act, the State Wetlands Protection Act, and they make a decision under the local bylaw. At issue here is really the local bylaw, but as a practical matter, they make the decisions together. They may make different findings under each the law and the bylaw and the act, but they make these decisions together, usually on the same piece of paper. And what happens if they're late, under the State Act, the applicant can immediately, within 10 days, appeal to the Department of Environmental Protection for a superseding order of conditions. And as a practical matter, at that point, a Conservation Commission would get its act together and issue a decision. But of course, there's always the possibility of a mandamus action.
Yeah,
Why shouldn't we conclude that at least the local issues are waived? I mean, obviously, the state wetlands issues are going to be decided by the DEP. If the proponent has not gotten a decision in 21 days, is going to appeal, right?
That's
so why
right.
shouldn't just the local issues be deemed waived if the local commission hasn't responded in a timely way?
Well, I agree, Your Honor, and what I'm saying is that would be a draconian remedy.
The wetlands are still protected by the state law, which is also pretty extensive.
Well, that's correct, but as we will get to, there are special interests that are protected under the local bylaw that are not protected under the state bylaw. If they were the same, then of course, there'd be no harm, no foul here. But in this case, there is quite a bit of difference between how the commission decided under the State Act and how it decided under the local bylaw.
Why don't you
I
explain?
take it that one of the things the court can do is look to see, there may be circumstances in which a constructive grant is permissible. Justice Glaney suggested there's no decision for 6 months. I take it here that there's a dispute as to the September 30th date. There's a dispute as to whether or not the commission decision was made on when it was in writing rather than when it was mailed, and so on. So that here there's nothing to suggest that what the commission was doing was attempting to ignore making a decision or declining to make a decision.
Well, that's correct, Your Honor. In fact, as I mentioned previously, I mean, it was only 2 days from the
Well,
time.
that's assuming that, assuming that we are bound by, and I'm not sure that we are, the Superior Court judge's conclusion. That is to say, we have the same evidence, and as a matter of law, it's not clear to me the import of the September 30th notice and the writing of the decision on October the 7th.
Correct, Your Honor.
There's no factual dispute as to what happens, am I correct?
That's right, Your Honor.
Nobody disputes that there was notice of a hearing for September the 30th. Nobody disputes that the decision was written on October the 7th. Am I correct?
That's right.
Okay.
Well, anyway.
Well, and in fact, where's the harm, Your Honor? Where's the harm here? It was a 2-day delay if, in fact, you find that the October 7th date was the date that the decision should be not only put down in writing, decided, and also mailed. And as I pointed out, there's always the possibility of a mandamus action to get the Conservation Commission to act.
Do you want to get to the other issues? Because your time is running down.
Yes, Your Honor, thank you. With regard to the preemption issue, let me just very briefly say the open meeting law issue, I don't believe this Court should even get to, because the open meeting law claim was brought under Chapter 30A, which is the State Administrative Procedure Act. That does not bind towns. A town is not an agency of the state government. I don't think you even need to get there because of that. But secondly, there was no open meeting law violation. The meeting was posted. The meeting was held in open. It was not secret. The proper documents were submitted, minutes and so on. There was no open meeting law violation. And if you look at my brother's claim, they simply are talking.
I think we can skip the.
Oh, okay. Thank you. Thank you. With regard to the preemption issue, both courts, both the Superior Court and the Appeals Court, failed to recognize that the local bylaw, as applied to this project, the dredging project, is more stringent than the state act.
But wasn't the real point of the analysis by the courts that even if that might be so, if the Conservation Commission doesn't articulate what it is in its bylaw that it is deciding on, it's impossible to tell?
Well, Your Honor, this is a record review case. You don't look just at the decision, and it's clear to me that both courts focused on the decision itself. It is an inartful decision. We will not dispute that. But you have to look at the total record. It's a record review case. And I submit that if you look at the total record, it's replete with evidence of what the Conservation Commission was focusing on. And what it was focusing on are two interests, actually three, but two of which are protected under the local bylaw, but not under the state act. And one was recreational shellfishing, and the other was the aquaculture activities that the town operated. And those were the two things. If you look at the record in our Section 2 of our brief, where we talk about substantial evidence, we point to all of the areas of in the documents in the record that support what the Conservation Commission was concerned about. And I will say, Your Honors, even if you look at the PowerPoint presentation in the record that the applicants actually put together, they clearly recognized on page 270 of the appendix that's before you, they clearly recognized that the opposition was all about recreation. Or focused, I should say, not all about completely, but focused on the recreational activities, particularly recreational shellfishing. I submit that both the Superior Court and the Appeals Court failed to recognize these legitimate interests, especially these two legitimate interests that are protected under local bylaw, that provided the basis for the Conservation Commission's denial, because both courts failed in their obligation under cert review to look at the record and cast about to discover some ground which reasonable men might deem proper and upon which the action can rest. And I'm citing here the Dubuque case in our brief. There is, as I said, substantial evidence in the record that the Conservation Commission was primarily concerned with agricultural recreation, agriculture and shellfishing, recreational shellfishing. Now, what's clear when you look at both the Superior Court case and the Appeals Court case is they didn't get it. They didn't understand that there was, this bylaw is more stringently regulates this particular project. If you look at the Superior Court decision at page 6, the Superior Court stated that it confined its review to what the town's bylaw, whether the town's bylaw is more stringent than the state act, but only as related to the protection of shellfish and land containing shellfish. It didn't even mention anything about the two interests that the Conservation Commission repeatedly referred to and is reflected in the record. And the Appeals Court said on page 5.
Ms. Georgia,
Excuse
excuse me, your time is up.
Oh, right. Thank you, Your Honor.
Mr. Quirk?
Good morning. Thank you very much. I'd like to answer the question that was asked by Judge Gurney. At page 424 in the record is the denial itself. Item number 3 asks about date of issuance. This is the town conservation's document. It says 10/9/2003. So obviously whoever filled this out believed that they issued it after the 21 days had expired. On top of that, the appeals court.
That is to say, if we are bound by the Superior Court judge's determination with respect to September 30th, correct?
Well, yes, but I mean, in terms of the town now arguing that it was issued on the 7th, its own document says the 9th.
No, I understand that. Yeah.
And I would also point out that with respect to the fact that because this is a dual process, the appeals court decision makes reference to 310 CMR 10.04, which also defines issuance as it relates to a decision from the Conservation Commission, and it says as the time of mailing. So they did not comply with the 21-day.
What do you do with the fact that there's no remedy set forth?
I understand the issue, Judge, and I think the answer to that is twofold. One is that the court has the discretion, I believe, to determine that there's been a constructive grant, or in the alternative, that the commission has lost its jurisdiction. And I believe that that's a lesser alternative, but a very valuable alternative, because what happened in this case was...
Well, then you win, because the local issues are out of the case, and the state has already said what you want to do is okay.
That's correct. But the other thing is that we did file the appeal on the 21st day without getting any notice, which is the statutory process that we do to DEP.
21st day from September the 7th.
Right.
No, 16th. I'm sorry.
Now, but with respect to the issue, Judge, of the 30th meeting, the town has its own bylaw, and that's in the record.
Right.
And under 5.6 of its bylaw, it tells how a meeting can be continued or a hearing can be continued. And after the 21 days has expired, the continuation of a hearing has to be approved by the applicant in order to do that.
So
and in this
is
particular...
Is reopening a continuation?
A continuation of the ongoing hearing.
Is that the same as a reopening? I took it they reopened it. They closed it for evidence, didn't they?
Right. They closed it for evidence, which then would require that the applicant be given notice and an opportunity to assent to them reopening the hearing to take evidence. The applicant was never notified. 5.6 says they must do this. And even though they're arguing that there's no issue with respect to the notice, the town filed as its answer the record. In the record, there's no indication that the September 30th meeting was ever posted. There is an affidavit that's never been acted on that asserts that they did that. But the other thing is that...
Excuse me, when you say the affidavit has never been acted on.
That's correct. It was filed, but because the town answered by filing the record, and it was not in the record, they filed an affidavit, which I assume was intended to supplement the record, but there's no decision to supplement the record by adding that affidavit with respect to what the clerk's office said took place. But the other thing that's significant about that is that what they did is on September 30th, they took in a document as evidence, which they say has no impact on their decision, and yet they make reference to information in that document in the decision. So they have tainted any decision that they have with evidence that violates their own regulations. And our concern is that these, under the regulations, the Conservation Commission is enforcing police powers here so that they have to be uniform. We have to have predictability. We have none of that in this case. They chose to do this. They took this evidence in. And then in the record at page 423, I believe, is the vote itself. There's no findings ever made by the Conservation Commission at its meeting with respect to support the decision.
Now, she says they could go, going back a little bit, that they could go for mandamus, or you could go for mandamus, which is somewhat, I mean, I'm sure practically you could do it, or legally you could do it, but sort of undesirable, because who wants to be suing the board and getting them all riled up because they haven't made the decision. But if the board is having trouble getting it out in 21 days, there are ways to extend that time, are they not? Could they say, bring the lawyers back, or bring the developer back, or whoever
There's
it is,
nothing,
and let's
Judge.
have another chat about this, and thereby, because we got some kind of problem here, and that would extend it?
There's nothing in the bylaw or the statute that reflects the chance of extending those timeframes.
Well, couldn't they post a notice within the 21-day period sufficiently in advance to reopen it and say, look, we're going to post a notice to come back in here for further discussion and
Yeah.
do that on the...
No.
Can't
I don't
do
think
that?
so.
Can't do
I
that?
don't think so. I think it's similar in terms of the timeframes that you do with zoning. I mean, there are times that are set because the original enactment of Chapter 131 was a balance between the public's interest in protecting environmental issues and the private landowner's rights to exercise their rights. So the time frame was supposed to be short.
Well, what if you wanted to reopen it to present additional evidence? Could you file a petition with them, and could they honor it?
I suppose it would be possible that we could do that, but they would have to accept that and open it themselves. We don't have any
Well,
control.
what about neighbors? What about abutters? Could then, if
No.
they don't make the decision within 21 days, could the abutters say it's too late?
Yeah, the abutters don't have the power to ask for an extension on the evidence.
Well, but can they take advantage of the fact that a decision has not been made within the 21 days at your request?
I don't believe so, because there's nothing in the bylaw or the statute that would indicate how they could take advantage of the failure to comply with the bylaw or the statute. I don't think that's possible. But the other thing, we should talk about this in context, and that would have been the 5th hearing on this application. So it's not something that was, rushed to judgment here. What happened was, at each stage, the applicants attempted to provide information that they thought was being asked. In the first place, the regulations talk about the fact, and administrative procedures talk about the fact that the commission is supposed to be giving notice to people of their concerns so that they can respond to them. At one point in this process, the commission said they were going to give questions, which answers would be provided to, and then we would have a continuation of the hearing. They declined to give us questions. We provided information anyway on anticipated matters that were in discussion. And the problem with this whole case is that there are basic issues that nobody ever got to. First of all, this is already an altered wetland. It had a Chapter 91 license issued, and it had been dredged previously. The issue is that we have scientific evidence in here that shows that this is no longer a natural shellfish area. There's a letter in the record from the harbor master, who's also the natural resources officer, that he's been seeding this area. It's a closed area because of water quality, and there's no public access to this area. So we have all these issues. We have 5 shellfish studies that demonstrate that the shellfish in this area are insignificant. We've been able to establish that the only reason there was shellfish there was because it was artificially placed there. We have an alteration of the wetland. They failed to recognize the alteration. They failed to address it. They made no findings. In fact, their motion, at the meeting that they made, all the motion says is motion made by Charles Palmer to deny the project as submitted. Seconded by Bill Zano. Motion carries unanimously. There's no findings. There's no nothing. Then when you look at the denial has information that was obviously never discussed at the meeting, but the denial makes reference to the state regulations. And the state regulations are the same things that were looked at by the DEP. And the only thing under the section that relies on the town bylaw as a value that they list to be concerned with is land subject to shellfishing, which was exactly the same thing covered by the DEP in its superseding order. So,
Excuse me, Mr. Quirk. I take it that that you agree with, I mean, the appeals court, despite, goes through all the procedural questions and then concludes that the town's bylaw does not appear more protective than the statute. That's not exactly, is it more protective than the statute?
I would say no. It adds two more interests without a definition. And we're talking about, the discussion here is that they were trying to protect recreational shellfish. There is no definition under the bylaw for recreational shellfish. There is the value word recreation. It doesn't define whether it's shellfishing, boating, or what other kind of recreation there should be. And they do have the word aquaculture. No place in the decision were those words ever stated.
So do we even have to get to the question of whether or not the town's bylaw was more protective if they didn't address those issues in their own decision?
Well, the case law says that when a reviewing court looks at a decision, they look at the reasons stated by the entity to determine whether they're valid or not. And since they didn't state recreation or aquaculture, they can't raise them. They've raised them in their brief.
What is your response to Ms. Giorgio's point that you look at the record and it's, I think her words were perfectly clear, or words to that effect, that what concerned the Conservation Commission was shellfishing?
That's not, I don't read that in the record. There's 460 pages in the record, most of which were put in by my clients.
About shellfishing?
They have 5 shellfishing reports that show that's negligible shellfish. The reports demonstrate that it's no longer a productive natural area. It shows that the water temperature is changing because flushing isn't taking place. There are heavy.
Am I correct that that's because a permit was given to extend some barrier where some property was being washed away?
What happened was that the Conservation Commission in 1993 granted the permit for a bulkhead. When the bulkhead was put in there, what happened was it changed the entire dynamics of the creek, and the sand came from the creek across, and now we're creating a sandbar.
Well, you may have all this evidence, and I'm sure you do, but there must be some evidence by the opponents or others that say, we're opposing this thing because of recreational shellfishing and aquaculture. I mean, there's got to be some in there, right?
Well,
so you put that together with the fact that the permit was denied, and it's intuitive and common sense that that was the reason.
I don't think that's a fair assessment, Judge, because we can't use intuitive decision making with police powers as I read the cases.
Well, that's a different
we have to have
issue.
Predictability, and we have to know what was.
Is there any requirement that they have to spell out their reasons?
The cases seem to indicate that in order for a court to review, they have to have the basics of findings and information to understand the reasoning of the entity that's made the decision.
Is the remedy here a remand, perhaps?
No, it's not, Judge, because they violated their own regulations. They've gone beyond their jurisdiction. If we send a remand back, what we're saying to the government is, you can make mistakes, we'll straighten it out by just sending it back, and then you can make the decision after all this information that prevents us from doing what.
On that point, though, the appeals court language is interesting. It says, we think local commissions must, at a minimum, provide in their decision some analysis to reviewing courts, but there's no citation, there's no...
I understand in that particular decision, Judge, but the other cases where they've made decisions, they make reference directly to the findings made by the commission to determine whether it's based on substantial evidence, whether it's arbitrary or capricious. The problem here is that I can't see how this court could determine it's not arbitrary and capricious because there's nothing in the decision that provides the court with any direction as to what they relied on. And there is many pages, as I say, 460 pages of record, most of which we provided, most of which supports what we say. And on top of that, we have the DEP superseding order, which approved the dredging, in fact, to solve some of the problems that we demonstrated.
Is the state, well...
Can I ask you this? The Rogers case, issued within days of this case, and this is a published opinion, is so close to this, it's hard to ignore it. They come out the other way. What is the distinction that you say?
Glad you asked the question. Judge, in Barnstable, they have in their bylaw, Article 27 is a definition of recreational shellfishing. They made 13 specific findings by the Conservation Commission as to how that definition and the actions being taken affected their decision, so that the court had something to go on and something to look at. The other thing, too, is that was creating a dock in an area that had not been previously altered. We're dealing with an altered wetland, and so we have some distinctions. On top of that, though, you should know.
I think, may I just say, and it may be that it wasn't here in the language, but again, there's a very big difference here if do you agree that there's a big difference if the local, whatever it is, bylaw in this case, is more restrictive than the state one, correct?
If they use those portions of the bylaw
I understand.
to support the decision.
But if it is, and obviously one of the things that concerned us was that regardless of the definition of recreational shellfishing, in the decision by the appeals court in this case, it seemed to suggest that recreational shellfishing, albeit not terribly well defined here, was somehow simply cumulative of the state statute.
Well, or the fact that in the record it demonstrates that the municipality has never established that this is a natural shellfish habitat now. It was, and the record shows that.
Why would that make a difference? Let's assume you can create, let's legitimately create recreational shellfishing, because my understanding is this entire creek was originally dredged, correct?
It was dredged, yes.
And so whatever shellfishing is there originally was created by human beings, correct?
No, Judge, that's not correct. What happened was
Not by seeding, but there was no...
No. What happened was that because of the dredging and the water flow, it developed into a shellfish area.
That's what I meant.
It was not seeded.
No, I wasn't talking
in the
about
beginning.
seeding. I was saying that there was no shellfishing there. Humans did something. There was water there, and the shellfish came in, correct?
Correct. But then what happened was, as this creek blocked off and the flushing stopped and the temperature went up, the natural shellfish habitat got lost. So what they did is they seeded it, and it's closed during the summer because the water quality is so poor that they can't shellfish. And then when they did the shellfish surveys that are in the record, it demonstrates that even with the seeding, there's no natural retention of shellfish in the area because the conditions are so poor.
Mr. Quirk, this may be beyond what we have to consider here, but did your client submit evidence that if there is dredging, the natural shellfishing will increase?
My clients suggested in the evidence that with the dredging and the flushing, it would return to the condition it was prior to the time that this bulkhead was approved in '93, which had the shellfishing. Yes, and I think the scientific evidence in there is the evidence from my clients, which talk about all of these elements and why dredging is necessary to revive the area. So it's not a question of us destroying it. If we don't do anything, this is going to become just an area with heavy metals, smelling, and the water will be cut off at low tide, and there will be no function. There will be no shellfishing.
Thank you, Mr. Quirk.
Thank you.
We'll take a short break.
Take